right out the gate that we today are going to be focusing on how to react when a law has been violated. And that reactive process just means essentially that there's already been some harm that we're trying to address. And that's distinct and different from asserting a right in order to prevent a violation from happening. We hope that you'll leave this presentation with a general understanding of the steps you have to take on behalf of a victim when their rights have been violated. And each topic that we're going to cover could really be its own long presentation. So keep in mind that this is really, hopefully, just the beginning of your learning on these subjects. And because we have a lot to cover, we won't be able to take questions in real time. But if we do have some time at the end, and we hope to, we'll do our best to answer any questions. And we would ask that you add those questions to the questions asked section in the presentation portal in the Whova platform. And that's going to also allow us to be able to follow up with answers there in Whova if we do run out of time. And there we've also added some handy dandy references to the relevant law, so you can check those out. Today, we're going to start with a discussion about the common concerns you'll see. And then we're going to explore how to determine if those concerns actually translate into a violation of law. And then after that, we're going to explore the strategies or most used strategies for deciding what to do when you think there's a violation. And then we're just going to end with some example work, some practice. So let's get started.
Thank you, Rachel. So when a victim has a concern about their rights and they're looking for help to address it, we see that there are two paths to help victims that victims often take. Most common, victims contact the DOJ, Office of Crime Victim Services, which is where I work, and victims are often referred to us by advocates or victim witness, or they find our office after doing some research into victim rights. There are various things that OCVS can do, which we'll get to throughout our presentation. And a little less common, but becoming more common, is that victims are connected to victims' rights attorneys like Rachel. Sometimes we at OCVS make the referral, or sometimes victims contact attorneys on their own. And there is a lot that attorneys can do for victims, which we will also be getting to throughout our presentation. So let's dive in. A victim comes to you with a concern. We first need to unpack what that means. And by concern, we mean a victim thinks that they have been treated unjustly somehow. This unjust treatment may or may not be a violation of law.
The longer you work in the world of victims' rights violations, you're going to start to identify patterns and trends related to the types of concerns victims will bring to you. And that's pretty interesting because norms and practices differ from county to county, courtroom to courtroom, agency to agency. But nevertheless, you will find, as Hannah and I have, that victims are likely to bring to you variations on the same issues. And Hannah briefly is going to go over some of those common concerns that we've identified. But we also first want you to keep in mind that victims rarely, if ever, come to you with a full and complete understanding of the laws that protect them. And that means that you should not expect to hear the magic words, "my right has been violated." That means that the first step in your work is to determine how, if at all, the facts and circumstances surrounding your victim's concerns correlate with enumerated rights. And it also means that you need to be open to the reality that you could wind up advocating for a concern that is actually totally different than the one your client initially brings to you. Because in talking with the victim about their experience within the system, you may very well uncover other potential violations that need to be addressed that the victim was not even aware of.
Like Rachel said, victims don't usually use the magic words, my right to this was violated, or I wasn't afforded my right to that. So it's our job as victim rights practitioners to help figure out how their concerns associate with an actual right in the statutes or the Constitution. So instead of quoting the actual right, here are some of the most frequent concerns we hear. We hear, I don't know what's going on with my case, or my case is taking too long. So we have to ask questions, a lot of follow-up questions to figure out what that means. Or we'll hear things like, no one told me there was a hearing in my case. So we might need to ask follow-up questions. Did you tell the DA's office that you wanted to be notified of hearings? Or we might hear, I disagree with the plea deal. So we need to engage in trauma-informed listening and asking questions to figure out, is that implicating the right to confer or the right to notice? We'll also hear things like, I had no idea that I'd have to expose my private life, or I was treated unjustly and I didn't even know I had all of these rights. So again, we have to ask a lot of questions to figure out what that means. Exposing your private life, was that in the criminal complaint, or did the victim's name show up on CCAP? Or was there something in the media? So again, asking a lot of questions to associate a concern with an actual right. We also hear a lot, no one will talk to me. And one of the most common things we hear is, I feel like no one cares about my case. So that will require a lot of questions and digging to figure out what that really means and what we can do to help address those concerns in the context of victim rights.
And just like there are patterns to the types of concerns we hear, there are actually also patterns to the subjects of those concerns. And additionally, the more you practice in the field, the more you're going to come to see that certain specific system professionals or agencies, courtrooms or counties may be more frequently subjects of concerns. And this can really be helpful. This knowledge that you gain can be helpful in assessing the veracity or validity of a victim's explanation of events. So like if, for example, you know that in a particular county, you hear a lot of complaints about a particular victim's rights issue, and this new person is saying some version of that again, that speaks to the reliability of the information that you're receiving from the victim about what happened. So most commonly, prosecutors, judges, law enforcement, and victim witness specialists are the subjects of victims' rights concerns. Less frequently but still common, are Department of Corrections agents and court clerks. And then every once in a while, you may come across a concern regarding a public official outside of the system. For example, perhaps a member of a fire and police commission, or some sort of elected official. You may also get complaints for other court staff or DA staff, and also prison and corrections staff. Okay, so you've got concerns coming at you, but not every victim's rights concern violates a law. And Hannah sort of already hit upon this example, but let's just say a victim comes to you and says, I wasn't notified of a hearing. That on its face pretty clearly implicates the right to receive notifications and the right to attend proceedings. But perhaps that victim did not request notification of hearings, or perhaps the hearing notification was mailed to an old address. Then this type of additional information opens up the possibility that those rights, though implicated, were not actually violated.
So how do we tell the difference between a concern and a possible violation? We have to be skilled at effective issue spotting in order to determine whether a concern amounts to a victim rights violation. Issue spotting is the key. And in order to issue spot, we need to do 4 things. We need to know the rights, know the system, know the remedies, and know how to listen, ask, and investigate. So we'll dive into those 4 things.
And the first way we do that is by actually knowing the rights, and that means knowing all of them. So the best way to do that is by reading, rereading, and then reading them again. Another way to learn about the applicable rights is to get connected with the victims' rights practitioners community. At the previous presentation, my colleague Ann Rufo, there's a victim rights attorneys work group that meets monthly. And on a national level, there are also organizations that connect practitioners to each other where they can discuss the issues that they're facing, ask for sample filings, and share the work that they're doing. Because this is such a burgeoning area of law, and there's not a lot of clarity on how to do things, it can be really, really helpful to build relationships with the limited few of us who are working on this and specializing in it. In addition, when you're working with these rights and working to understand them, you really need to enter in and engage with this other system professionals with the notion that you may understand these rights and have spent more time with them than they themselves have. You should never assume that that judges or prosecutors or any of the other people that you engage with are as familiar with the law as you. They might be, but you shouldn't assume that they know what you know. In addition, when we're contemplating what these laws mean and working to understand them, it can be helpful to look to precedent and the work that's happening outside of your community. Learning more about the best practices in application of these laws is useful to giving you ideas about how you can utilize and make sense of them. And finally, we encourage you to be creative and be bold in your advocacy when it comes to potential violations of rights. This is a common refrain throughout this conference, but the reality is there just isn't clarity on how to do things. And that is an opportunity for you to try and test different forums and formats to make your arguments. And we encourage you to do that. And to be a zealous advocate when it comes to proper enforcement of your client's rights. But it also requires a realistic and reasonable understanding of what you can achieve and within the complaint process, and with the understanding that you are entering into a system where there are just a lot of questions about what is the right and wrong way to handle victims' rights violations.
So just as knowing the rights is hugely important, knowing the system is important as well. And knowing the system means a lot of things. For one, it means understanding operational norms. And those norms, I think we all know, can vary from county to county and even from courtroom to courtroom. So knowing these norms of how court systems work and victim rights are exercised from courtroom to courtroom is obviously not something you can learn at the drop of a hat. It comes with time and experience and connecting with the victim rights community. But part of knowing the system is also knowing when you can push back. So if a prosecutor or a clerk, for example, tells you that's how it's always done, or you can't do this, you can use your experience to demonstrate that victim rights enforcement can be done in other ways. And knowing when it's appropriate to think outside of the box is a really useful skill.
When assessing victims' rights concerns, we also need to actually know what remedies exist when a potential violation has occurred. And perhaps put more accurately in the context of victims' rights, we need to know the limitations of what we can ask for. We as legal practitioners are taught from the very beginning that with every right there is a remedy, and you need to know what you can ask for. And although most typically in other areas of law, that may be, for example, monetary damages or penalties of some sort or court orders, there are some pretty specific limitations about what we can ask for in the field of victims' rights. Our laws don't really attach any specific remedies to the rights. On the other hand, there is language within Article 1, Section 9M and Chapter 950 that expressly limit what types of remedies a victim can ask for. And most notably, damages for the harm caused are prohibited in most ways. And the other reason it can be challenging to identify appropriate remedies in victims' rights law is because it's really hard to unring the bell after a violation has occurred. The harm has been done, and oftentimes that involves something happening in either the investigation or a criminal prosecution that you're not really in any control over. And as a result, cases may proceed and investigations may continue and move on while you're still trying to sort out what happened and, if possible, fix it somehow. Another limiting factor in our law is accountability or the application of violations and remedies when there is concern about a judge's action or decision regarding a victim's rights. There is very limited case law, but that case law does exist that articulates For example, that the Crime Victims' Rights Board cannot sanction or make decisions regarding potential victims' rights violations by a judicial figure. And because there are so many limitations and so little guidance on what a victim is entitled to, you really just need to instead decide what your remedial ask will be based on the victim's goal. And in this slide, we've given some examples of what those goals might be and how you might achieve some sense of resolution for your client. And that really does require thinking outside of the box. Finally, it's critical in our assessment of victims' rights concerns that we know to listen, ask, and investigate. The reality is that victims and their representatives have very limited access to case information, and typically there is not much of a record kept about victims' rights applications throughout the process in the criminal justice system. And so we, as practitioners, where we would normally look to receive, written documentation, reports, transcripts, et cetera, that can become more challenging in this field of law because we just simply don't have access to a lot of that information. That really means that we rely heavily on our ability to effectively make sense of the information about the facts that we're receiving from our client. But it also means that we need to look to get explanations and additional information where we can within the system, and recognizing that everyone that you're talking to has their own perspectives on what happened and their own biases. You can always, for example, ask for records associated with the case, but most likely you won't be getting those records unless the investigation or the case are completely closed. Therefore, when we explore or probe a concern, we need to be taking a holistic approach to seeking out information, contacting the subject of the complaint, listening to the client and asking the right question, getting as many case specifics as we can with understanding those limitations, considering all of this in the context of how the system is actually operating, where this concern lies, and then applying those relevant laws.
So, let's assume that you've evaluated the concern in the context of the facts and the relevant laws, and you determine that you think your client's rights have been violated. What do you do next? It's time to strategize, and you need to decide 3 things: whether to complain, where to complain, and how to complain.
Deciding whether to complain first requires a pragmatic, realistic evaluation of what that process entails. And when we're entering into this part of the analysis, the most trauma-informed way to approach it is to ensure that your representation is survivor-led. And being survivor-led means making sure that you are gathering all the information you need from your survivor and really listening to the survivor. when they answer those questions to get a sense of what is best for them as an individual dealing with the trauma of the crime, and also any trauma that has resulted through their experience in the system. So we have to ask ourselves and our clients certain questions. The types of things that you need to be considering when you're deciding whether or not to pursue a complaint might be, what are the short and long-term objectives? Can the tools that are available to you adequately address the harm that was caused to your client or victim? It may be that the benefit or the systemic trauma that might be compounded by pursuing a complaint actually outweighs the benefit of pursuing it. And if the tools aren't sufficient and a person may experience additional harm, we need to consider whether that it's a reasonable approach to pursue the complaint process. We should also be considering, what is the likelihood of success? That can be hard to predict because these laws have yet to be defined in the traditional sense and legal sense. But we can look to what we know about the system where we are entering with our complaint, and look back at how past complaints have been received to give a realistic explanation to the client about whether, even though we think the case might be strong, whether others will agree with us. We should also be asking ourselves whether there's a broader community interest in the outcome of the particular rights violation that you're considering complaining about. And finally, it's important to consider timing. Is now the right time to pursue this violation? And that really depends a lot on what your victim says their priorities are. Which brings us to the types of information that you need to get from your client to decide whether to complain. What do you hope to achieve by complaining? How would you feel if we don't prevail? And in an ideal world, what would you want to have happen in the criminal investigation or the criminal case? And that's really important, particularly when we're contemplating the right time to complain. Because if, for example, your client has a strong interest in making sure that there is some sort of criminal accountability, and you're in the early stages of the investigative or prosecutorial process, entering into one particular path to deal with the complaint that might be particularly adversarial may be problematic for your client who wishes to have some accountability, criminal accountability for the crime. You also need to have honest conversations with your client about how litigious they're prepared to get. That helps you determine where to complain. A victim may come to you feeling really upset and outraged about what they've experienced and want to shout from the rooftops and hold people accountable as publicly and as strongly and as forcefully as they can. But as you explain that system and what it means to engage in that type of litigation and how that impacts their lives, they very well may reevaluate that. And does maintaining goodwill matter to your client? If there's a particular interest in ensuring that the person who violated the rights continues to work well with the victim, if that's important, that's something that you need to be factoring into your decision about pursuing a complaint. Oh.
And after deciding whether to complain, you next need to decide where to complain. So we've categorized the options into 4 different routes that you can take. And we've intentionally ordered them from what we view as least adversarial to most adversarial. So first, direct advocacy. Second, the Office of Crime Victim Services. Third, the Crime Victim Rights Board, which has to come after the office, can only come after the Office of Crime Victim Services. And fourth, the court system.
And we're going to go into quite a bit of detail about what each of those routes entail. But before we do that, we want to highlight the methods that one can use regardless of the route you choose. And the way we complain, the method we choose is really contingent on the route we take. And unless you're initiating a complaint, for example, in the circuit court system or through the appellate system, there are, as we've mentioned previously, really very few rules that guide or control what tool you use and how you use it. But in general, the same tools that you might use in other types of legal work can potentially be of use here. Those might be simple things like conversations, phone calls, meetings, dialogues, written documentation that isn't like a court action, such as letters, FOIA record requests, victim impact statements, statements of facts, and the use of forms. And then finally, most formally, you can also pursue complaints or file motions, file replies, seek injunctive relief, pursue appellate options as well. But no matter which of the 4 routes you decide to take, what's really, really important to prioritize is building and preserving building the record and also preserving the issues as you move along the various routes, because it is possible that you may move through one path and then shift to another route. So the first route that we are calling direct advocacy is essentially good old-fashioned talking. It's easy to overlook, particularly when one is feeling outraged and there's an interest in sort of strongly sending a message about a victim's rights concern. However, oftentimes the most efficient and effective way to resolve a victim's rights complaint is to go directly to the source. We shouldn't overlook the power of conversation. When we enter into direct advocacy, what we're really talking about is setting up a dialogue, a forum that feels comfortable for the victim, for the subject of the complaint, and for you to take time to address this issue together. And it's important to keep in mind, if you go down this path, that you really are steering this ship. You are in control of the conversation and how it happens. And so you set the tone, and don't forget that you lead the conversation. But it is also critical that though you may be steering things, that you encourage participation and openness and receptiveness from all involved. One thing to really consider when you are deciding whether to engage and how to engage in direct advocacy is, how are you going to frame this issue? Are you going to frame it as a concern or a complaint? You may decide that if you believe that the subject will be receptive and responsive and eager to resolve the issue, that calling it something less confrontational, like a concern, may be appropriate. Calling someone up and saying, you know what, this thing happened to this victim, and we're really concerned about it. And we're wondering if you would be willing to help us sort it out. On the other hand, if the particular issue is serious, if you are aware that there's sort of an ongoing issue, or if you have a belief that perhaps the subject won't be as responsive or receptive to you, it may be appropriate to call it what it is and call them up and say, my client's rights have been violated. We want to talk to you about our complaint and figure out a solution to it. So what does this really look like? First, you need to find the right point of contact. And oftentimes that's, for example, a victim witness specialist, but really your goal is to find the person within the system who will be an ally and will be responsive and supportive as you and the victim try to address this issue within the system. Then once you connect with that person, and perhaps the subject, you really want to be clear about what the issue is and your perspective on things, but to then ask for theirs. From their perspective, from their understanding of the case, what happened? And also be very clear about what your client wants to achieve through these conversations. Once you've explained what you want to achieve and what the issue is and heard from them, you need to be sure first to ask them whether they have the capacity or ability or desire to help you achieve the outcome that your victim is seeking. And assuming that they do, it's great to work together to collaborate and develop a plan, a solution that has mutually agreed upon solutions to the issue at hand. And then after you've established the shared action plan, you need to be sure that you are being reasonable about giving folks the space and time they need to fix the issue on their end and to actually take the steps that you've talked about. They have other priorities in other cases and are also very busy. And as we know, the criminal justice system moves fairly slowly. So it is important to be mindful that things may not happen as quickly as you or your victim may want. That doesn't mean, though, that you just have to wait indefinitely for them to take the actions that you've agreed upon. So it's important that you are also really clear in establishing expectations about receiving updates and the timeline for achieving the change that you're seeking. And hopefully the people on the other end will be helpful in setting reasonable expectations about that.
So after direct advocacy, the second route we want to discuss is the Office of Crime Victim Services. So this is known as the informal complaint process, and it's governed by Wisconsin Statute 950-08 sub 3. So you could think of it as, you can think of the informal complaint process through OCVS as mediation, where a victim rights specialist, such as myself or my two colleagues who do this work, aims to resolve the victim rights issue through relaying concerns from the victim, gathering information from the subject of the complaint.
And from a victims' rights attorney's perspective, the Office of Crime Victim Services can be a very helpful resource in addressing victims' rights violations, because they really do have access and trust with the players in the system that you don't. It is helpful to be able to reach out to someone at OCVS and say, you know, this thing happened in this one county, and I don't know who to talk to or where to go to make sure it doesn't happen again. And oftentimes with a phone call like that, the victims, the specialist will be able to get connected with the right person to promptly resolve the complaint that your client has. But when you do decide to engage with the informal complaint process, I would suggest that you go into that first really with clarity on what exactly the issues are that your client wants to address, which rights are implicated, any special needs that your client might have, and what your end goals are. And ideally, you, although not required, you would put this in writing. I have found that when I summarize all of that, essentially in usually a letter, that it has been helpful in ensuring that both the specialist and you are on the same page about what issues they are working on in their informal complaint process, particularly if there are several. It ensures that there are mutual, there's just a mutual understanding of what we're hoping to accomplish through the informal complaint process. And having that document can also be helpful if your end goal is essentially getting to the Crime Victims' Rights Board, because that document can also serve as the foundation for a complaint there. And in this process, you also need to be aware that it is pretty collaborative and not particularly adversarial. And that means that you'll be working closely with the specialists as they try to engage in conversations and gather information to come to a resolution that feels good for your client.
The informal complaint process through OCVS is initiated quite simply. So a victim and their attorney, if they have one, contacts the OCVS Victim Resource Center. Their complaint is triaged and assigned to a victim rights specialist who will then discuss the concerns with the victim and will create an action plan about who to contact and which concerns to raise. So, and our action is completely victim-led. We don't contact anybody without discussing it with the victim first. So after we have gathered information about the victim's complaint, we'll contact the subject of the complaint. For example, a law enforcement officer, a prosecutor, a clerk of court, a probation agent, any public official, as the statute says, and we will relay the complaint. So an example might be the victim is saying that they weren't notified of a plea and sentencing hearing, so they weren't able to exercise their right to give a victim impact statement. We'll ask the subject of the complaint for a response and relay that back to the victim. And we'll go back and forth as many times as necessary until all of the victim's complaints have been addressed. And an important part of this, too, is an opportunity to discuss best practices with the subject of the complaint to try to avoid this issue in the future. So after we have finished mediating the complaint, we prepare a closing summary where we summarize the victim's complaint and the responses we received from the subject of the complaint. And we'll provide that to the victim along with information about the Crime Victim Rights Board. So if the victim believes that they want to proceed to the formal complaint with the Crime Victim Rights Board, we'll provide a complaint form. And the statute states that victims have to go through the informal complaint with OCVS before they can go through with the formal complaint with the CVRB. So we keep these complaint forms pretty close to the vest for that reason. So we talked about the first two routes. The third route that we wanted to discuss is the Crime Victim Rights Board. So following the informal complaint process with OCVS, victims have the opportunity to proceed with a formal complaint with the CVRB. And this is a good option for victims who prioritize an actual legal determination of whether their right was violated. We don't make that determination with the informal complaint process through OCVS, but the CVRB does. And although victims can file an informal complaint with OCVS at any time, there is a point where I don't call it a statute of limitations because it doesn't strictly stop it. But if victims do file a formal complaint more than 3 years after the potential violation, the CVRB is limited in what they can do as a remedy. They can only issue a report and recommendation. So keep that 3 years in mind. 3 years after a violation occurred. Keep that in mind with complaints with the CVRB.
And the Crime Victims' Rights Board is really, it does carry a lot of weight and has a lot of authority, but it's also pretty mysterious. The Crime Victims' Rights Board complaint process is confidential, which means it can be challenging to, do your own research into how they operate and what they do. That said, there are very helpful staff with the Crime Victims' Rights Board who are always able and willing to answer questions and to give you a sense of whether, for example, the format for your complaint is something that makes sense to them. But you can still do what you can to familiarize yourself with the board before you do it or before you enter into it. We have provided the relevant laws in the statutes and also in the admin code that apply to the Crime Victims' Rights Board. Those are saved in Whova for you. You can look at those. You can also look at past Crime Victims' Rights Board decisions and recommendations. Those can be found at the Office of Crime Victim Services website, where there's a link to the Crime Victims' Rights Board. You can also learn more about the board makeup. And really, though, entering into this complaint process is a little bit more adversarial and may feel, from a lawyer's perspective, more familiar insofar as there's a lot of written filings and you have a burden of proof. The burden of proof is on the complainant in this process. So this is your time to state your position persuasively and to preserve your client's options along the way.
So how does the CVRB process work? It starts with the victim, with the help of their attorney, if they have one, filing the complaint form that they've been given by their OCVS victim rights specialist, and they can file it with any supporting documentation they have. And then the respondent is notified and asked to respond to the claim of the victim rights violation. And then the CVRB reviews the complaint and decides whether there's probable cause that a victim rights violation occurred. If the CVRB finds no probable cause, the complaint is dismissed, but a victim can appeal that decision to the circuit court. If probable cause is found, then the board begins an investigation, which may even include an evidentiary hearing. So the victim and their attorney review the probable cause findings. They can request a hearing if they believe facts regarding the violation are in dispute, but the CVRB doesn't have to hold one. The CVRB then investigates the complaint. Victims are not provided with an investigative report, but they are provided with a copy of the final decision. So if the CVRB does find that a right was violated after reviewing the facts and the applicable law, there are several options for a remedy or sanction. The CVRB can issue a report and recommendation about the issue. They can issue private and public reprimands. They can make a referral to the Judicial Commission if the complaint is about a judge, since they cannot sanction a judge themselves. They can seek equitable relief on behalf of the victim, or they can bring a civil action to assess a forfeiture if they find that it was an intentional violation. So that's known as the fine. You may hear people talk about, I don't want to get the fine related to victim rights. So that's what that is. Although I will say I have not seen that happen. So the fourth and final route that we want to discuss in our last 5 minutes is complaining through the court system. So Rachel will go into more detail on the options and the process.
Thanks, Hannah. Yeah, so, the court system, because it's public, may feel familiar and easy, and that may be your instinct, but it actually can be pretty difficult to navigate a victim's rights complaint in the system, because it just isn't done with a lot of frequency, and there can be a lot of confusion around the process. So that means that you need to be prepared when you enter into the system with with a victim's rights complaint, to explain your position, why you're there, and all of the relevant laws. You need to be really meticulous and thorough, and making sure that whenever possible, you're following the proper procedures. And as always, you need to make sure that everything is on the record, because in the criminal system, that's not always the case. There are 3 routes to complaining in court. First, you can raise the issue within an existing criminal case. Second, you could raise the issue through a separate civil action. And third, you can look beyond the circuit court to the appellate system for relief. So if you are pursuing a violation within the circuit court in a criminal case, this really just starts with a notice of appearance. That may seem obvious, but because you're not a party, a victim isn't a party in the case, the process is a little bit different for a victim's rights representative to get involved. So you file the notice of appearance, and you can submit a complaint by either e-filing or by asking the DA's office to submit it on your behalf. because you're not a party, you would be e-filing as a third party. A complaint can be articulated really in any way. You might use the form that exists, that CR 296. You could also submit the complaint in a letter form or through a more formal motion. Regardless of what form you decide to use, what's key is that you are making it clear why you have the legal authority to be there asking for what you're asking for, and that supports your chosen method. And you should be in that complaint requesting a hearing, an oral or written decision. Our law very clearly articulates that a court needs to respond to complaints in a timely manner and make a decision and provide an explanation for that decision. And throughout this process, you need to be prepared to explain why you're there, because people may be confused. And a lot of those same processes apply if you're starting some new type of civil action as well. What is really key, though, here is to recognize that in a civil case, the court and the court staff aren't used to necessarily utilizing victims' rights laws. So they may be confused because there is such overlap with a criminal case as to why you're in front of them with this particular civil legal issue. But that just means you need to have an explanation, a good explanation for why this is the proper venue, why you have standing, and that the complaint is properly filed where it is. And finally, if the violation that has occurred is particularly impactful and the facts are ripe for appellate review, it may be appropriate to pursue that. But obviously, seeking appellate review for a violation of a right is not something that you can do every time a court may decide something that is contrary to your victim's position. Our statutes, our Constitution does specifically articulate that a supervisory writ is an option if a circuit court violates a right or if there's an adverse decision in regard to victims' rights. Obviously, though, you're not guaranteed review. You can petition for review, but there is no guarantee that that will be accepted. And regardless of which of these four routes you use, we want to be sure that it's very clear that the rights that your victim has in the criminal case apply as well to all of these other proceedings and routes. So wherever you're complaining about a rights violation, you need to be sure that you are being protective of their rights in this next step of complaining as well, and making sure that you're asserting those rights and making sure that all of the parties involved in moving that through the process are compliant with victims' rights. And I know we started a couple minutes late, so hopefully this is a really important slide, so I hope you'll bear with us. We want to sort of summarize the key considerations when determining which route is best for your victim when there is a victim's rights concern. So the first thing to consider is if maintaining good relationships matter. We briefly touched on this, but if there is a reason why your victim needs to be able to work well with the people who may have violated their rights, and there's no alternative, good relationships matter in that case, and direct advocacy and the OCVS process may be useful ways for you to address the violation.
And if the issue is fixable, then a similar answer, then direct advocacy or the informal complaint process might be the best option. An example might be a victim wasn't notified of a hearing. That's pretty fixable going forward. So a phone call or an informal complaint might be the best option.
On the other hand, if some sort of accountability or public acknowledgement of the violation is a priority to the victim, then those routes aren't necessarily going to achieve that. And you may need to turn to the Crime Victims' Rights Board, or if public acknowledgement is the top priority, the circuit court system. Meanwhile, Hannah, I'll just dive into this one. If acceptance of responsibility is important, the more adversarial you are, obviously, the harder it is to get that acceptance of responsibility up front. And so direct advocacy and again, OCVS provide forums that feel comfortable and more safe for that type of acceptance of responsibility.
And again, if there's trust that once a complaint is brought forth and addressed and acknowledged, then it won't happen again, then direct advocacy and might be the best option in that situation. If, however, if there's a pattern or history, that direct advocacy may not do the trick. You may need the Crime Victim Rights Board to say this was a violation, or the circuit court to say that as well.
If privacy is important, then the most private ways of pursuing action are to, of course, do the Office of Crime Victim Services informal complaint process, the CVRB process. It is much more difficult to handle this privately and confidentially in the public court system.
But just like the court system is private or is public, it's not very quick. And the Crime Victim Rights Board isn't very quick either. So direct advocacy or informal complaint are the best options if time is the essence.
And we've already sort of talked about why the priorities in the criminal investigation or case matters. But I guess in summary, if those are priorities to your client and they aren't always, then the more collaborative routes are likely to achieve your client's goals with the complaint. On the other hand, those routes can, well, not so much the OCVS route, but when there are multiple subjects and multiple issues that you're dealing with, it can get really complicated trying to navigate those conversations and connect that network yourself. And direct advocacy can be really challenging in those situations. And ultimately, it may then make sense to go through the more formal processes.
And then our last point, and then we'll let you go. So thank you for hanging with us, is if the subject of the complaint is a judge, reminder that the Crime Victim Rights Board could only refer that to the Judicial Commission for a ethical violation. So if the subject of the complaint is a judge, then the court process is really the best way to have those complaints addressed.
But of course, that has its own challenges as well, because you are essentially going to the court to say, my rights have been violated by you. And that can be a tough uphill battle. But there are certainly lots of judicial officials who are all are wanting to make sure that victims have a voice and that their rights are respected through this process. So that is the route to go, though it does have its own diplomatic challenges that go along with it. And with that, we hope that this has given you a broad overview of what to do when a victim comes to you with a concern about whether their rights were violated or not. And we hope that you enjoy the rest of this conference and that we will be working closely with you in the future. Thanks a lot.
Thank you, everyone.